If someone who works for you commits fraud without your knowledge, should you be able to spend the rest of your life in prison for it? There's an obscure federal law in the books that raises a pretty important question about where corporate responsibility ends and where personal criminal responsibility begins. The Continuing Financial Crimes Enterprise Statute is basically the financial version of a kingpin law. Under the law, someone who organizes, manages, or supervises a continuing financial crimes enterprise involving at least 4 people and receives at least $5 million from it can face anywhere from 10 years to life in prison. And that idea makes sense on its face. If someone knowingly builds and runs a massive criminal enterprise, being removed from the day-to-day operations shouldn't absolve you of responsibility. But there begins to be a problem when you apply that same language to a modern day corporation. Think about how a large company today actually operates. A CEO might oversee thousands, tens of thousands of employees. They delegate enormous amounts of responsibility to executives, managers, lawyers, accountants, department heads. They rely on financial reports that they didn't personally prepare, audits they didn't personally conduct, and information from subordinates that they couldn't possibly verify line by line. So consider what happens when someone further down the chain commits fraud. The CEO technically supervises the people involved, but did they supervise the crime? Because that's an important distinction. And when a statute uses broad terms like organizes, manages, supervises, that distinction becomes even more important. Because obviously being a CEO shouldn't protect you from prosecution. But being the person at the top of an organization shouldn't automatically prove that you knew about crimes beneath you either. And that brings us to Daniel Chu. Chu is the founder and former CEO of Tricolor, an auto lender that primarily served working class borrowers. Federal prosecutors allege that Tricolor employees manipulated loan information and pledged the same collateral to multiple lenders. Prosecutors also allege that Chu directed the scheme. Now, Chu has pleaded not guilty and disputes these allegations, but prosecutors have gone a step further than simply charging him with fraud. They've charged him with this rarely used financial kingpin statute, exposing him to the possibility of life in prison. And this case could set an important precedent about how this law is used against corporate executives going forward. How much does the CEO actually have to know? What does the government have to prove about their personal involvement? And at what point does supervising people become legally interchangeable with knowingly supervising their crimes? Those aren't just questions for Daniel Chu. Those questions could matter for anyone running a large company. Now, prosecutors have an interesting opportunity to show us exactly where they think that line should be drawn. If the government is going to bring a rarely used statute carrying the possibility of life in prison back into use, Americans deserve an extraordinarily clear standard for when corporate management becomes criminal leadership. People who knowingly commit fraud should obviously be prosecuted, but criminal responsibility is supposed to be personal. The government should have to prove that you knowingly participated in a crime, not simply point to your title and the crimes of someone somewhere in your chain of command. When the potential punishment is life in prison, the difference between supervising someone who committed a crime and knowingly supervising the crime itself is more than a technicality.